And you also love it when they change the license law. So guess what? They changed the license law. Now they did this ostensibly for one reason. They came along to do it because they said that, well, our nomenclature is not right. You guys are now all brokers, not agents. And so inside the pamphlet, they were going to change it and make it all agents, right? Unfortunately, what they did, and what oftentimes happens when it gets turned into the legislature, there are unintended consequences. So here's what we have. Let's back up a little. So what they're going to do is they change the rules when it comes to dual agency. How many people in the room practice dual agency? Okay. How many people say no way, no how, no form, no shape? Okay. 2 or 3. Okay. Well, in this case, they're changing the way the dual agency is handled. Theoretically, they're improving the timing of the agency disclosures. They're formalizing agency relationships with buyers, and they're clarifying how dual agency happens. So if, in fact, you do dual agency, or if you don't do dual agency, this law still affects you. So how does that happen? In the past, when you did dual agency, this is how you did it, right? The majority of people simply check the box that the selling agent represents both parties and the seller's agent represents both parties, right? That's how you disclosed it.
Yep.
And you may have had a conversation with the seller at the time you listed the property, and you said to the seller, you know, there's a provision in here that says that if I sell the property myself, that I'm allowed to be a dual agent. And what that means to you is that I'll treat you fair and honestly, and I'll represent your interests, but if I've got a buyer that wants to buy the property, and I can also represent them. And that's about the extent of what most agents say.
Oh, no.
I said most, not all. Good, I'm glad you said that. I'm sure you spend more time in that. But many, many agents kind of gloss over that whole paragraph. They just kind of go on, because it's in the first paragraph, and it also says things in there that if in fact somebody from my office sells the property, that my broker can be a dual agent, and you authorize that to occur too. Okay. Again, most agents don't spend a lot of time in the weeds there. Maybe they should. Well, they're going to have to do something different now, because this no longer works. This will no longer suffice to meet the obligation to disclose dual agency in the state. So how does it happen? So we all know, effective July 1st, if we have a signed agency agreement with the seller, that's our listing agreement. So we obviously have to represent the seller. Okay? And how many people have ever had a team? You had co-listing agents, and then all of a sudden a buyer will come along, and that buyer is over here, and one of the team members says, well, I'll just go represent that person. And I'll be the buyer's agent there, and you represent the seller. But yet they signed the original listing agreement, and the seller was told that he had 2 listing agents. So effectively, you really couldn't do that. Okay. People were doing it, but you weren't doing it right. Not just you, but everybody, because you still had a listing contract signed. So what's the next step? And then sometimes we had a signed agency agreement with the buyer, and that's a Northwest MLS Form 41. That is a form that Northwest MLS came up with, a form that is pretty generic and easily used. There are other buyer agency agreements out there in the marketplace, but this one is kind of a universal, ubiquitous. It's out there a lot. And so that's what the buyer's signed agency agreement looks like. And when do we use it and why? Well, again, effective 1. When is a buyer-broker agreement required? Well, guess what? It's going to be required every time you sell one of your own listings and are a dual agent. Let me say that again. If you're a dual agent and you sell your own listing, that's the same thing, right? Before you can sell your own listing, you have to have a contract with both parties. And they have to be independent contracts. Are you with me? You have to have a buyer agency contract, and you have to have a listing contract.
What if you already have the contract and you don't have the buyer agency agreement signed? You're already a pending party. What do we do now?
The law takes effect July 1.
Oh,
There's no look back
oh, thank you.
because they recognized that everybody was doing it the first way by checking the boxes.
Yeah.
Okay? So what they've got now is, now there's even some, if you read the verbiage in the new law, the RCW, there's debate whether or not before you could sell any of the listings in-house. So you sold her listing. There's some debate whether I, as the broker, would need to have a buyer agency contract signed with your buyer, as well as the listing agent having a listing contract. There's some debate about that. We're not going to cause that to happen. We feel that that is like, if that's the way they interpret it, come and get us. Take us down. All right? Because that's way too onerous on all of us to think that your buyer who's writing hers, you're going to still, I'm going to be a dual agent, okay? Or your broker's going to be the dual agent. But to have you required to do a buyer agency contract just so you can sell her listing, we're not going to choose to do that. Are you with me?
Well, the question I've got is the corporation, let's say the corporation that, which is the broker, and the designated broker, of course, one's an artificial person, one's a real person. Which one is the broker as far as dual agency
Well,
is concerned?
the firm has a delegation agreement. That's how it works. The firm nominates and delegates the responsibility to what we call the managing broker or the designated broker. Okay? If it's a designated broker, then the designated broker then delegates to the managing brokers, like Nate, like myself, at the current time, that we have authority to be the dual agent. So that's how it works. It flows that way. You're correct, though. It's the firm that actually has the contract. Okay? It's the firm, not the designated broker, not the managing broker. Let's move a step further. So, when you're representing a new buyer, we've developed, as a response to this law, an informational page, what we call the buyer's acknowledgement and options. Let's look at it together. It's the first page of this handout that you've got. Okay? And this document was created after about 4 iterations to try and take the heat off of you as much as possible, but yet also meet the obligations of the law. And we've vetted this both with Annie Fitzsimmons at the state, who is, of course, the hotline attorney, and with Justin Haig, who's Northwest MLS attorney. And both of them said, wow, you guys are way ahead of the power curve. Nobody else has come up with anything like this. And this shows that you're being responsive to this new law and actually taking it seriously. Because frankly, somebody's going to stumble and fall this time around. Before, you could pretend to be a dual agent and not really do it. We're going to talk about unintended dual agency and talked about botched dual agency and those things in a couple of minutes. But I'm just letting you know that we took the responsibility that says our brokers are not going to be that way. We're going to give them some ammunition to sit down and talk with a buyer. So here we have it. So what this is first of all, it's an acknowledgement that they've got the law of agency and the buyer's agency contract. They don't have to sign a buyer agency contract. It's no requirement, except if they buy your listing and you're going to be a dual agent. But those that raised their hand and said, I'm never going to be a dual agent, you're not going to have to worry about ever having a buyer sign a dual agency clause or having to sign a buyer agency agreement. But you can, and this option says, buyer's options for representation with working with the listing broker. As a buyer, you're entitled to representation, right? You should be having that conversation. And you can choose who you have represent you. That's true too. As a listing broker, by contract, I automatically represent the seller. Another truth. When working with the listing buyer, you have 3 choices for representation. And then we lay it out for them. You can be represented by a broker of your choice. You can represent yourself. And the listing broker can represent the seller only. And by the way, if you haven't done that, try it. In other words, just because you show your listing does not mean you have to represent that buyer. In fact, on some levels, it's better that you don't, because we're going to talk about how difficult it is to be a dual agent and do it correctly. Very difficult to do. Not impossible, but very difficult to do. But you also do what we're doing in here. So that buyer looks at you between the eyes and go, well, if you're representing the seller, who's representing me? And you say, well, you can represent yourself. But I still owe you a duty of reasonable skill and care. I still owe you a duty of acting fairly and honestly in all dealings. I still owe you a duty of disclosing all material defects with the property. And I have a duty to account for all monies that I handle. Those are general duties of any agent, right? So when you tell a buyer that you got to act fairly, you got to act honestly, you got to use reasonable skill and care, you got to tell them anything that's wrong with the property that you're aware of, all of a sudden the level changes a little bit, and they're not going, well, I'm out there on an island by myself. Not totally. So we took the middle paragraph and say you can represent yourself, and in this case the listing broker can write the offer, but they still owe you those duties. Reasonable skill and care, honesty and good faith, disclose material facts that are not readily apparent or ascertainable to you. And you can ask the listing broker to represent you as well as the seller, if the listing broker agrees to do so. You don't have to agree to do that, right? You can say, I'm going to refer you to Rob, or Robert. I know your name's Dave, so I got a couple names down already. But I could refer you to them and take a referral fee. The law allows that right now, correct? Okay, so you can do that and be a happy camper. But just trying to get ahead of the power curve, if the listing broker is a dual agent, the law requires a written agreement specifying the agency relationship with the broker and the firm. The agreement must include the terms of compensation. That's a key element, by the way. It's not just a buyer agency agreement. It also has to say how you're going to get paid. And if you looked at the buyer agency agreement on the second page, if you look into the area where it asks for compensation, my recommendation and suggestion to you is that you write in there such as selling broker agrees to accept as compensation the SOC, Selling Office Commission, published in the Multiple Listing Service. Okay? So the selling broker agrees to accept as compensation the published Selling Office Commission in the Multiple Listing Service, and then, depending on you and yourself and I, but not less than blank %. Now, in our world, where I'm at, our rules say that I cannot negotiate my commission. I cannot negotiate my commission on if I'm a selling broker. I can't walk in because you're offering 2% and write in there that the selling broker will receive 3%. I can't do that unless I have a buyer agency agreement that allows me to do so. So if I have a buyer agency agreement that allows me to do so, I can negotiate up front. That's a sidebar issue. I don't want to get too deep in the weeds there. Just know that you need to write something, because it says one of the conditions of this buyer agency agreement is you have to have compensation identified, how you're going to get paid. And if you write in there that you're going to get paid as a result of the published SOC, most people are happy campers, right? Because they're not paying it. And someday we may be able to get paid by buyers. Yes, sir.
Yeah, and this probably isn't a good question, but good chance in my market we might sell them a for sale by owner. How do you address that into compensation?
Sure. Then what you do there is you accept compensation from the seller, but not less than X percent of the sales price. Yeah. Yeah, you can definitely do that. And then you actually write it into the contract. Seller will pay. You know, there are some FSBO forms actually. Northwest has some FSBO forms that work pretty well, especially back in the distressed property days when we had a lot of that going on. So, West of the mountains. So we're representing a new buyer client. We initial meeting. Now, what do you do when somebody walks into an open house? How many people sell open houses? You guys have an open house? Yeah. Okay. Glad you do. So you're trying. No. Well, some people give up, you know. I mean, but anyhow, if you have an open house, somebody walks in, do you have to whip this document out and say, hey, before you can look at this house, sign this document? No, you don't. However, if they say, gee, you know, I think I want to buy this place. Let's meet with your lender. Then all of a sudden the tables turn. You pull out the first page and you say, you know, before we go into another step, I want you to understand something about representation. And that if, in fact, I'm going to sell this property and be a dual agent, then I need to have a buyer agency agreement signed. The law changed this July 1. Blame it on the legislator, okay? Don't take the heat. Don't take the heat on yourself. Blame it on the legislature. All right, so I'm going to quickly go through a couple things. So what about open houses? What about sign calls? You know, I was over in Othello yesterday talking to those guys. They're dual agents almost every day. You know, because they're selling farms and ranches, and as they said, you know, if we list a farm, we know the buyer before we even get out the door. We already know. We got to list the buyers. You know, and so we're going to be dual agents all the time. So if you get a sign call or an ad call, again, you don't necessarily have to whip out this piece of paper and present it to them immediately. However, if you're going to choose to be a dual agent, you got to take this next step. It's up to you. You know, you have choices too.
But,
I have a question on that.
but
Yeah.
Dick, I need to correct that, because aren't you guys asking that when we're working with all buyers, this document, this acknowledgement document, we're
We'll
supposed
sign.
to present this to all
Right.
buyers? That's what our brokerage approach is. At one point, the attorneys at the state level said before we spoke to any buyer, we were gonna have them sign a buyer agency agreement. And I thought, great, I don't even know this person, and I'm asking them to sign an agreement. So what we've put together is this informational and educational document, and we're gonna ask for this from all of us in the whole company. This is our current interpretation.
Yeah.
So the front document, yeah.
Yeah, no question about it. When you write a purchase agreement, we're still going to ask you to fill this form out and have them sign it as an acknowledgement. Think of it as an ARD, acknowledgement of receipt that we have, right? So, yes, no question about it. I'm just simply saying when you meet someone on the doorstep and you're walking into the house, you're not necessarily pulling out this piece of paper at the same time. But if you sit down to write an agreement, even if you're not a dual agent or even if you're not going to have a buyer agency agreement, still we're expecting you to get this form signed. This is going to be kind of a company-wide requirement so that we know that you've had this conversation and have met the requirements that the law has now imposed on us. Okay?
So we're not required
No, you're
to
saying
get it
this-
signed prior to showing our own listing.
Say again?
We're not required to get it signed before showing our own listing. So if I get a signed call on my listing, go to show it, I don't have to have it signed.
You don't have to have it signed instantaneously.
Okay.
But when you start talking about buying, or remember now, how many times do you sell your own listing off a 4-call or a sign call? Not that often, but you do pick up buyers, and you do go see other houses, and you try and sell them something else. Perfect time to start talking about, you know, let's work together. This is how I'd like to work with you. Let me tell you how I work. One of the things I do is I follow the law. The law said January 1 or July 1 that from this point forward I have to identify who I'm going to represent and how I represent them. This is frankly, folks, a transition to no dual agency. 3 to 5 years from now, I'm not a forecaster, but I've been around a long time, 35 years in this business, pretty rough. And I've seen a lot of transitions go through. This is one of them. This is just a stair-stepping to no dual agency. It's happening in other states. May not be good, but that's the trend line. Yes, ma'am.
So I can see sitting down with some people and where it says you can represent yourself. And so we've had this relationship with the buyer, look for houses and everything, and then we sit down to go over this, and it says you can represent yourself and the listing broker can represent the seller only. I can hear some people saying, oh, I can represent myself and save the commission, or I can get the commission or whatever. I mean, basically,
Yeah.
that will
Yeah.
come up.
So it's a good idea to spend some time figuring out what your dialogue would be. How would you respond to that if somebody said that to you?
Are you a licensed real estate agent?
It's not what it's talking about.
Yeah,
That's
it
the
is.
seller.
They could
Or the buyer.
represent, they
Buyer,
could,
are you
after you
licensed
show them the
realtor?
house,
We
they
can't
could
pay you
choose not to
compensation.
have
That's
you
not
represent them.
legally.
Not very diplomatic, is it?
No.
Wait a minute,
that's
one
not
conversation.
So your clients are
Rebates
asking to
allowed.
be paid the commission?
Yeah, or if they say, well, okay, with them, Piper, we don't need you, we
Right,
can
and you
represent
can say,
ourselves.
you know, that the commission is paid to licensed real estate brokers. It's not paid to command.
Yeah, the contract, you could simply refer back to the listing contract. The seller agreed to pay both
Right.
the selling agent and the listing agent the commission. And
But they-
representation, you can get, just like selling agents don't represent the seller, but they get paid that commission all the time.
But I also kind of see a loophole that if we didn't have a buyer agency signed with them in the beginning, you know, that they could think, well, I mean, they could just walk out and think, well, I'm gonna go directly to the listing agent
You are the
and
listing
save,
Oh.
maybe they'll cut me a better deal if I don't have two agents.
That happens all the time. And by the way, the interesting part is, you know, everything you're describing has occurred. There are a lot of, stuff like that happens all the time. In fact, where I'm from, again, the MLS rules say that in the event that the seller cancels the listing and then relists with somebody else and they lower the commission, the difference between what they agreed to sell it to, the commission that you agreed to and what they lowered it to sell it to someone else. Because we've had people, buyers go, hey, why don't you, the listing agent, sell this thing to me? Cut the commission to 4%, you still make out, I make out, the seller makes out, we're all in good shape, right? The difference is paid to the listing broker that was number one. Am I making that clear? I'm not sure if I'm making that clear. The difference, in other words, you're not getting away with anything, okay, is what happens. But you're gonna have to develop some dialogue around this, no question about it. You're gonna have to practice this, because those kind of questions are coming up. It's a good question you ask. And I would just suggest to you that you spend a little time thinking about explaining to people that representation doesn't necessarily equate to compensation, and it doesn't. Selling brokers don't represent the seller, but yet the seller pays them a commission. Is that not true? Yes,
And
sir.
I think the really wise buyers would realize that if you're double dipping on your own listing, that gives them all the more incentive to make sure things come together.
Well,
Not that you would do anything that you shouldn't do as a dual agent.
So we're going to talk about that in just a second. So here's what some of the options that you have. You can represented by another broker, opportunity to refer, discover who they are represented by. In other words, you know, you can find out real quick at an open house when you say to someone, are you working with another agent? And they go, yes, we are. And then you say, well, who might that be? I might know him. And they go, well, what's his name again?
Just real quick, in the last 3 years, we've had this conversation come up about the commission after the agent already showed them lots of homes. And a client said, I'm ready to buy it, but I want you to rebate 1%. So this conversation with those people will come up regardless. If you control it, you can minimize it with the others. So
It's an interesting point of view, though. Buyer represents themselves. You can write the offer. They only represent the seller. You can work as a dual agent. That requires a buyer-broker agreement. And only you, the seller, and the buyer can consent to dual agents. Okay. Let's see. How did we get to the rest of it? Okay. Let's back up a second. Assigned buyer agency options and acknowledgement form required for all buyers prior to showing any of your listing, excluding open houses. Prior to showing, meaning at the time that you decide what you're going to do, if you're going to continue to work with them. We definitely want this signed before you sign any contract. If you sign a purchase agreement, we're wanting this as part of the purchase agreement. Just like we have an ARD signed, acknowledging receipt of the law of agency pamphlet, that the lead-based paint addendum signed, or they've gotten the Form 17, we're expecting this as well. This is turned in on all sales. It will be in paperless, so on your copiers, there will be a packet already set up, and then it will be added to the paperless pipeline checklist. So when the staff looks at the file, they're going to have a checklist on all the different documents that you need. This will be one of the documents added to it.
For
when it's a
any
buyer
buyer.
only. For buyers only.
Okay, any buyer.
Any buyer. Yeah, any buyer on any listings.
So I'm working now with 3 buyers already. We're not gonna, if we write the contract
After
after
July.
July 1st,
Right.
I'm gonna have to get this
The
signed.
front page. The front page. Might not be a bad idea,
I'm
the
gonna-
second thing.
We've done this now with all the offices, because we're all like, boy, this feels like a barrier. But a lot of the brokers are turning this around, saying with every buyer, we should be sitting down with them. This is our valuable time, and we're representing them. And this is a one-page tool to have the discussion about what services you're gonna provide as a buyer's agent, and explain the difference between dual agency. So if they're going to a side agent, this happens a lot, and we all have different cultures. So you showed the property, and they go back to the side agent, and the side agent writes the deal. This happens all the time. If you have this conversation with them about being a buyer's representative with everybody, your guys' time is valuable. It's funny to me that we run out the door. With a listing, we're very good, but we run out the door on a sign call, which we do, but we don't really value our own worth. So a lot of them are saying this is a way to have that conversation, get out the agency pamphlet. What is that as defined? It's not compensation. What are you doing representing them? So we defend your commissions all the time when other brokers when they've gone to another broker or all of that. This gives us the tool to say we have this conversation, and then in a buyer's agency agreement is you're worth what you should be earning. So it's really, if you can switch this thing around and really make it a way to differentiate yourself in the market as a better broker, because every brokerage is supposed to do this. We don't know what they're going to do. The law has changed for every brokerage in Washington State. We know that some brokers aren't even going to have this conversation. But you can educate and inform and say, this is why you would work with me. This is why you'd work with a REMAX broker, because we are at a level of mastery that other brokerages aren't. So there's a different approach to this, and it feels when they first sent this out, the legislator said to us, we couldn't believe it, is we're all signing a 41A, a buyer agency agreement, before anybody walks in any of our listings, and we're like, are you kidding me? Sure, I'll meet you at the house. I'm REMAX, I get my sign calls. Remember, that's one of the reasons we're REMAX, right? It's not going to the floor duty guy. It's going to us because we're stronger listing brokers. And oh, by the way, I'm going to block the door until I haven't even created a relationship. But Dixie's going to talk a little bit. Because you're in an agency relationship already, Ronnie. You're in there. You have confidential information. You're there. Let's acknowledge it and define it and really explain it to them so they know what your duty is to them.
Yeah, let me just share with you real quick. So one of the real estate commissioners is in my office in Tacoma. And when this first came out, he knocked on my door and he said, hey, Dick, about the changes in the law. And I said, yeah, you're amending the pamphlet to put in the word broker. And he goes, oh, no, it's more than that. I talked to Bob Mitchell. And if you don't know who Bob Mitchell is one of the GA people, government affairs people at the state. So I call Bob on the phone and say, hey, Bob, is this really true that every time one of our agents shows any company listing, they're going to have a buyer agency agreement? And he says, yeah. I said, oh my gosh. And after I cleaned the puddle up under my feet and I got, back up, I said, I can't believe this. Can't be true. So the more we noodle it, the more we read it, the more we vetted this thing through the system, we discovered that that's not true. It only applies theoretically to me, the broker, that I'm supposed to have a contract between the two, but we're not going to exercise that. We're going to just simply say the agent, if you're going to be a dual agent, you're going to have a buyer agency agreement, period. Okay? And all we're asking you to do in addition to that is to have this first front page sign so that the buyer is acknowledging the fact that agency relationships exist, they have choices in those agency relationships, and that you've had a chance to discuss it with them. Now let me just cover real quickly why or why not to be a dual agent. So who can think of reasons why to be a dual agent? Well, a lot of good ones, right? 1, you get paid twice as much. 2, you control the flow of paperwork. 3, when things need to be done, you can get them done more quickly than anybody else, right? You don't have to rely on the other agent to do things. The paperwork flows easier. At crucial points in the contract, you get to handle them all. Okay? Well, all right, those are good reasons too, but why wouldn't you want to be a dual agent? Well,
You're locked down.
all of a sudden, when somebody needs to get blamed, there's only one person to blame. That if somebody's asked to pay for something, there's only one person to pay for stuff. Does that ever happen? Okay. If you screw up, there's no one to blame but yourself. It's fraught with pitfalls, just fraught with pitfalls and uncertainties. Seller may not like it after you discover what it really means. You may say, I'm going to represent you when I take the listing, and I'm going to look out for your interest and get you the highest price in the least amount of time and the least inconvenience, right? That's what boom, 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 boom. You got all that memorized. And then you bring in a buyer and you go, all of a sudden, well, now I got to walk down the middle of this path here. And no longer can I be your advocate, and no longer can I be that. Well, wait a minute, that's not what I really wanted. That's not what I was buying, into. That's not why I hired you. Well, that may be a reason you choose not to do it. DOL will be on you like white on rice if you screw up. Two things at the state level get charged more than anything else with problems: property management and dual agency. In my career as a broker for 20 years nearly, that's been the biggest problem, is dual agency. Not done right. So how do we have unintended dual agency? You doing it now. Unintended dual agency. How does that happen? Happens all the time. You write an offer, you check the box that you represent the seller, and then all of a sudden the buyer's agent disappears. And the buyer calls you and says, I've got these appointments. I've got to get into the house. I've got to measure. I've got to do this. I've got to do that. And you can't get a hold of the buyer's agent. And you haven't been able to talk to the broker either, because I don't know if you have these things over here. They're called discount brokers, where they got 150 agents and nobody knows what anybody's doing. And the broker doesn't even know the names of the agents in their office. Believe me, I just had this happen to me the other day. So you all of a sudden start talking to the buyer, and the buyer starts telling you confidential information. And do you step back and go, whoa, time out. I don't want to know anything about you. I don't want to know the name of your kids. I don't want nothing, right? Unintended dual agency. What happens when your buyer and your seller both call you and you both call me, and we actually talk about the sale with them without the other agent's knowledge or consent? So the buyer calls you up and says, well, when is the seller moving again? Can we get early occupancy on this thing? And you start answering a question like that, and the other agent doesn't know you're talking to him? Those are all unintended dual agency situations. You write an offer for a buyer on a FSBO, and all of a sudden the seller starts confiding in you about their situation. Another example, you ask about FSBOs. So let's talk about intended dual agency. Intended dual agency. There are 4 do's. You decide, you disclose, you document, and then you do it. You decide if you're going to be a dual agent. You disclose that you're going to be a dual agent. You disclose, you document, critical part, document, and then you do it. Now, who's seen botched dual agency before? Because that happens all the time. The minute that you have let's pretend that you've written an offer and that you've got the buyer as well as the seller, but yet you're only representing the seller, but yet all of a sudden when you talk to your seller, you go, well, my buyer wants this. Or the minute you say my buyer, or my seller, depending, you've blown it. Because in their mind, they no longer have your strict allegiance. You're no longer just their agent. Don't become an unintended dual agent. Don't botch dual agency. If you're going to do it, you have to do it correctly. We put up on there what the duties of a dual agent are. What's perfect dual agency look like? Your mother sells a home to her grandson and she leaves to go to a retirement community, and you represent them both. All right? Or your seller on one home wants to buy one of your listings. They pay full price, don't require any repairs to the property, and the seller goes out with them for a beer and they invite you along. That's about the only time dual agency works. Okay? Doesn't work a lot. Be cautious. From a broker standpoint, you've got to be cautious on these things. So just to know, you want the seller to love you, the buyer to love you, and even after the transaction, you want them to love you. Not all of a sudden get upset with you and go away unhappy because you didn't do what you said you were going to do. All right, any questions on this? Long presentation.
I just kind of want to go back. I'm a little confused on FSBOs because I've sold FSBOs before.
Sure.
And I've represented both, and then I've represented just the buyer.
Okay.
So I'm representing just the buyer, is there something, just like a buyer has to sign this, that a seller has to sign something like it?
Well, what do you use to get the seller to pay you? What document do you use to get the seller
An
to pay you?
agreement, or, I forgot the name of it, it's a FISBO commission.
Fish flow commission, okay.
Yeah.
And on that FISBO agreement, it says on there whether or not you represent, because you'll have a little check box. So you just represent the buyer. There's not a problem with not representing the seller on the FISBO. In fact, they're announcing to the world, I don't need you, right? Basically, they're announcing to the world, I can do it on my own, okay? So I'd let them do it on their own. And I'd only go as far as helping the seller to the extent that it really helps my buyer. In other words, if they're screwing things up,
Timelines, yeah.
you gotta help them. You know, if they're not getting ready for the appraisal, you gotta coach them, stuff like that. But other than that, I would avoid any kind of dual agency on FISBO. I really would. Unless, of course, they're gonna go buy one of your other houses. Have you ever had that happen, you know? In fact, that's one of the techniques, I don't wanna get into it, but one of the techniques of hitting FISBOs is saying, you know, I know you were gonna sell your house your own, but what are you gonna do in the future? Are you gonna find a house? I can help you do that. Anyway, that's a different story. That's 35 years of listening to Mike Ferry or something, I can't remember what. Any other questions? I didn't mean to upset you too much. Kim doesn't mean to upset you too much. None of us mean to upset you. We just want you to do it the way the law requires, and we want to let you know that we really respect you and your questions, and if you've got any, and you just like yours that you asked me about, I think that's the kind of conversation that we should, as a group, engage in, because frankly, we all need dialogues. We all need to come up with different strategies to meet this new demand. Yes, sir.
I have a quick question. They can go and sign 40 of these with all the 40 agents they've looked at houses with? It doesn't create a contract, correct?
Correct.
Okay.
All
I'm
this is
just
strictly an
thinking,
acknowledgement.
No, I signed one with Windermere and
Right.
two with Century 21.
Yeah. Well,
Oh, okay.
Yeah.
You can still write them up and go, oh, I signed them, so I have to go back to
Well,
the agent, but thanks for training.
Not on the agency agreement, it matters which
Oh.
box is checked,
Okay.
exclusive or not.
That's what I thought, that's why I.
yeah, buyer agencies, yeah, buyer agency agreement. But those are terminated at will. Those are an at-will contract, so you can
Okay.
terminate it, they can terminate it with a written notice. The 41A is what I'm talking about.
No, but then, I think a lot of buyers may assume that this is a dual agency agreement.
Well, that's why you have to have.
But
it.
that's
Yeah,
okay.
Yeah. Well, it may put you in the catbird seat in terms of, but you know yourself, if you are gonna be a dual agent, you gotta go one step beyond
Right.
that and get the buyer agency agreement out. Yeah, yeah. It's an exciting time in real estate. Hopefully you feel the same way, because honestly, when you're good at what you do, you set the standard, and you can show a difference between your skill sets and your professionalism and the other guys. That's really what we're all about. We want to raise the bar just a little bit. And I can tell you, you asked about other brokers. I stood in the midst of 5 other brokers. We were all meeting. We all made the mistake of showing up at this place at the wrong time. We're all standing there, and I turned to the Windermere guy. And I said, so what are you guys doing about the new agency law? Huh? Turn to this KW guy. What are you doing? Huh? CB guy's over here. What are you doing? Oh, well, we heard something about that. I mean, you know, it was just ridiculous that they had, maybe it's because Pilot's in the office, one of the commissioners, that I heard about it quickly. Thankful that it happened that way. But nonetheless, you are the recipients, I think, of the cutting edge. When you get it vetted by Annie Fitzsimmons and you get it vetted by Justin Haig, 2 of the top attorneys in the state when it comes to these things, and they said you guys are ahead of the power curve, that's a good indication we're on the right track. Okay? Thank you very much.